Good afternoon, everybody. My name is Virgil Breeden. This is my fifth post in my war on corruption in the Mississippi courts. This video, I'm afraid, is going to be a little disjunct, and I apologize. I made one video outside on the 21st, on the 22nd of the month, and it was a little too long. It was on my cell phone, and I couldn't get it back to this iPad. So I went out earlier and made another video out there on the iPad, and for some reason or other it got messed up. So I came back inside thinking that the first video was good, did a second section, and it's okay, and I'm going to use it. But I do want to mention a few things before we go any further. This is about the Constitution of the United States. This is the last video I will make specifically relating to the United States Constitution. The following videos, the ones that come after this in the next few weeks, will be about those things very specific to the corruption in Mississippi courts, cases where they have ruled completely contrary to the Mississippi Constitution and to the Constitution of the United States. Briefly, I do want to say that on Monday the 21st, I was able to speak with Dr. Ralph Bell. Dr. Bell is the new Chief Medical Officer for the Mississippi Department of Corrections. A very intelligent individual, and most importantly, Dr. Bell, in assuming his post, realizes that there are very serious problems in the medical care afforded to prisoners in the department, and he is seemingly very interested in approaching those problems simply, approaching those problems head on, and getting them taken care of. I look forward to actually meeting with Dr. Bell very soon. I hope that we do have the permission of the commissioner. I'm also going to ask to meet with Ms. Gia McLeod, who is the director of the Inmate Legal Assistance Program for MDOC. But I do want you to know that I did have an opportunity to speak with Dr. Bell, and I believe this is a person that you as Mississippi citizens, or perhaps family members of individuals who are locked up, can count on to try and make some very serious changes in the medical care that's being afforded to prisoners. Right now we have a company by the name of Vital Core Health Strategies. They're doing an awful job, terrible job. The CEO for Vital Core is in Topeka, Kansas. Her name is Viola Riggin. I have tried to call her a couple of times, haven't gotten her yet, but I'm going to keep right on trying. You guys know that already. So I do want to add one last thing, and then I'll get on to the other videos. This is kind of messed up anyway, and I promise you I'll try to do a better job next time. But you know, I'm an old man, so I'm going to use that as a little bit of an excuse. I do want to make a quick apology. I'm on Instagram, and I have been very flattered at the number of people who are following me on Instagram, but about the only thing I've done there is to post pictures. And the people who are following me, unfortunately, there are many of those who are individuals posting the pictures of beautiful women, and you know, they say, well, you look like the kind of a guy I want to spend the rest of my life with, and all this kind of stuff, when actually all they want to do is perpetrate a scam. So please understand that the people who are sincere, I haven't been following a lot of people back. Perhaps down the road I will try and weed out those who are sincere. I will make a separate video approaching scamming and some of the things that you can do to both identify and to get rid of scammers in a hurry. I have developed a little bit of a quick trick which works beautifully, and there's some things that I will explain about how to detect a scammer whenever they try to approach you. But that's neither here nor there, has nothing to do with this. It's just that there are a lot of people who are following me, and I'm not following back, and whether that be on Instagram, where most of them are, or any other of these social platforms I'm on. It's not because I'm being aloof or rude or don't wish to speak with you, it's because I'm here for this agenda where I fight the courts, the corruption in our courts. And this is going to be a big time fight. So please accept my apology if you are a sincere person and have started following me. Like I said, perhaps down the road we can get together and talk a little bit. Other than that, I'm going to go to the second part of this video, which I just finished making. So really this I'm going to have to back up and put it to first. And I apologize, guys. I'm trying to learn this technology as quickly as possible. It's just things that I'm not particularly familiar with. There are little bits and pieces there that I'm picking up on as quickly as I can. I do thank you all so very much, and I will remind you that this video is about the U.S. Constitution, and I'm going to tell you right now, before the rest of the video starts, that judges have told you so often that you cannot sue the state, that you cannot sue, for example, the governor or an official of the state. Whenever you sue someone, you sue them in one of two capacities. You can sue a business entity as a business or as a separate entity, but when it comes to a person, you generally sue them in their personal capacity or in their official capacity. And if they are a politician, such as the governor, then judges will tell you that you can't sue them in their official capacity. And you say, well, why not? And the judge says, well, it's because of the Constitution, and specifically because of the 11th Amendment. And of course, you know, judges know everything. They know absolutely all there is to know about the law and the Constitution, and they would never blatantly lie to you just to protect the state of Mississippi, would they? Of course not. I mean, these are like the creme de la creme. They wear suits and they have robes. And here I am, some old turkey out in the country who has nothing, who's got a bad back, a bad knee. I've got an appointment with an orthopedic surgeon on the first, probably have to have a knee replacement on the left side. I'm wearing a $2 pair of jeans I got at the thrift store, a $1 t-shirt. I got $3 to last me till the end of the month. But we're all in this together. We all run into problems and we deal with them the best we can. But here I am telling you that the judges are wrong. That the judge that tells you you cannot sue the state of Mississippi is an idiot. And you're saying, you old country hayseed, do you think I'm going to believe you? You better come up with something really, really good. Well, I'm going to try to do that. So let me get to the second video, which I made before this video, and then to the other one, which I actually made on the 22nd. And God forgive me this time. Please don't wander off into the universe just because I'm a somewhat incompetent old man. This is far too important. It's about Mississippi. It's the only thing that I've got left to fight for. There's nothing left of me worth it. But I'm going to fight this fight, and I'm going to fight it for you, because you are worth it. You are my fellow Mississippians, and I love every last one of you. So let's get on to the other part, and let me see about trying to get all this stuff put together to get it online. Thank you so much. I just came back in, and I was going to start the part of the video that I made on the 22nd, but there is something else I want to add, and I apologize, guys. I don't mean to talk too much. I do want you to watch everything and understand just how important this is to the state of Mississippi. But this is going to be my last post on the U.S. Constitution as an entity. The next post that I make will be specifically on the Mississippi Constitution and some of the things that our judges are doing to that. On the way in, someone asked me why I was not scared to mention judges' names, and that's because they can't do anything to me, and what they're doing is wrong, and I'm going to stand up for Mississippi for as long as I am standing and as long as I'm breathing. Judges don't scare me. The people who have threatened me don't scare me. As I told you, I was threatened out of Hattiesburg. Someone said, if you don't keep your mouth shut, we're going to send somebody. Please, just send them on. If you're going to send somebody, let's get this over with. But I'm not going to sit down. I'm not going to lie down. This is too important. It is what I've said about the U.S. Constitution. It breaks your heart once you realize what's going on, and I'll explain it in the rest of this video. If we had a wise soul in the Mississippi judiciary, a Solon being a wise lawgiver, a wise judge, and they came upon a case where someone was trying to sue the state of Mississippi, they would back up and say, you know what, it doesn't matter how long this has been going on, this is wrong, this is not what the Constitution says, and I'm going to do something about it. But you know what, when you're a freaking coward, nobody's going to stand up to it. Now, we do have a few, not nearly as many as we should have. We do have some good judges, and we do have some good lawyers. I went before a judge in a lawsuit that I had against the Mississippi Department of Corrections. I sued them about the length of my hair. Long before I was locked up, my hair was like 38 inches long. I believe that it should be long. That's my personal belief. And they made me cut it, which made me very unhappy, and I sued them. I won an injunction because of that. But I went before a federal magistrate by the name of Walker, if I recall, and one of the things that we can do as quote-unquote pro se petitioners, that is, individuals who are bringing their own actions and don't have a lawyer to represent them, one of the things we can do is play a little bit of a pro se game. I did that with Magistrate Walker. I walked into the courtroom, and in front of the attorney, one J. Chadwick Williams, who was representing the state, I said, "Excuse me, Your Honor, motions in limine." Well, that was not an appropriate motion to make. And I knew that. I know exactly what a motion in limine does, what it's supposed to accomplish, when you can use it, when you can't use it. But I wanted the judge to respond and see what he said, and his response was, well, not right now. But it also had another effect. J. Chadwick Williams was given to some measure of arrogance, and I think that he believed that because I inappropriately asked for motions in limine, that here I was, some idiot prisoner who had read a little bit about the law and was trying to make himself look good, and it worked. He came back with a response to something that I had submitted, and he quoted a case. The case was Holt, H-O-L-T v. Hobbs, and he took a little excerpt out of that case and tried to use that to traverse, to set against what I had said. And what he failed to do was to read the entire Holt v. Hobbs and understand the substance of Holt v. Hobbs, because it completely underwrote what I was saying and was completely against what he was saying. It's the substance and the understanding of that case law which he simply didn't get. But I went before another magistrate judge after this judge, I think he retired, Robert P. Myers. And we had another defense lawyer there, Brittany Eakins. And I must say that Ms. Eakins is an individual of character. Even though she was defending against what I was trying to do, I have great respect for Ms. Eakins. But I made the same motion in front of Judge Myers. I wanted to see what he would do. It tells me a lot about what judges will do and won't do, and how I can approach the courts. And in the times that I've tried to help people, I've used a lot of these little ploys to find out more about what to expect, and by the time we get to something serious, I can predict pretty well every word that the defense is going to say and what the judges are going to say. But I said the same thing in front of Judge Myers. I said, excuse me, Judge, motions in limine. And he stopped. And he took the time, briefly, to explain what a motion in limine was and the fact that it was inappropriate. And I said, well, Your Honor, I apologize. I thought it was just a motion that you put to the court at the beginning of the proceedings. And you know, I'm just trying to learn a little bit about all of this. Magistrate Judge Myers looked at me and he said, no, he said, I think you know a lot more about this than you might let on. So he was a very perceptive individual. And not only that, he took the time, a brief time, for an old pro se petitioner to give me an explanation to help me understand the law, which he thought I may not understand. And I appreciated that. This is the kind of fair proceedings that I repeat, every judge, magistrate in the state of Mississippi, in the federal district courts, and in the Fifth Circuit should look to achieve this kind of integrity and this kind of character. And if they did, I probably would not be sitting here raising holy heck right now because of what's being done to the state of Mississippi. So again, I apologize for this extra bit. The next post will be about specific things that have been done in the state of Mississippi and some of the ridiculous rulings from judges. Someone did ask me just a minute ago why I wasn't scared of what these judges would do and why I was not scared of mentioning their names. Well, you got that figured out. There's nothing they can do to me. They stole my life. What else are they going to do? You know, put me back in jail, shoot me, kill me. You know, bring what you got, because I'm going to be here and I'm going to be here until the end, because this is Mississippi. These are, I'm not sure how to say it, these are my people. So just get used to it. Take me out or listen to what I got to say, because I'm going to say it. I thank you, and I'm going to splice this in if I can figure out how to do that with the rest of this video, and I apologize for being long-winded, and I beg you, please listen, because it is important, and I hope that you will give me the subscribe and the like, so that this gets out to many more people, and we're fixing to get on to the next part. All right, we're back inside. It's raining outside, not much, but enough to get you wet. The fact is, I hope it storms today. I love these storms when it gets dark and stormy. It like I said, it touches my soul. That's kind of where I am, where I live. But right now, let's get on to the business at hand, the Constitution of the United States, and whether or not the Constitution of this country tells you that you cannot sue the state you live in, that you as a citizen of Mississippi cannot sue the state of Mississippi. And they always quote the 11th Amendment. Let's take a look and see what that says. This is my copy, one copy, I've got plenty, of the Constitution of the United States. I've used this many, many times. The 11th Amendment, judicial limits. This was ratified on February the 7th, 1795. Now I want to read this word for word. It says, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state." I want to read that one more time. Please listen carefully. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. What did we just read? Judges tell you that you can't sue the state you live in, but the Constitution said your state, for example, Mississippi, cannot be sued by citizens of another state. The Constitution said that this state, Mississippi, cannot be sued by citizens or subjects of any foreign state. Did I miss something there? It did not say that a citizen of a state cannot sue the state in which they live. So how in the Sam hell are judges telling you that you can't sue the state of Mississippi, or you can't sue any representative of the state of Mississippi when that lawsuit would be, in essence, a suit against the state? Well, that came about in 1890, and it is a result of a single judge, a dude by the name of Harlan, a judge on the United States Supreme Court, and it was in a ruling from a case known as Hans or Hans versus Louisiana. In that case, this judge, Harlan, made up his own mind that the inability, the lack of the right to sue the state that you're in was actually what the framers of the Constitution meant to say. Well, it's not what they said. And you've got 74 people together that are very intelligent. They put together a remarkable document. This Constitution, sitting right beside me right now, is without a doubt, next to the Holy Bible, the most sacred document in this country. These people were smart. They said what they meant to say. And in fact, later on and in another case, United States Supreme Court Justice Antonin Scalia said the script is the law. He didn't say, you just make up what you want. You can misinterpret, you can reinterpret, you can focus everything on your own personal agenda. You can just play with words, you can do whatever. He said the script is the law. This script is so purposefully written, and it leaves out the proscription or the preclusion, keeping from. It leaves out that because they found it to be so simple. They said citizens of another state or citizens or subjects of any foreign state cannot sue a state in this union. They did not say that citizens within the state cannot sue the state, nor would they have. What were they trying to do? Why did they make this so blatantly clear? They made it clear because this is what happened with monarchies, where the monarch could not be sued. And in fact, in Hansville, Louisiana, Harlan mentions the monarch. This is the very evil that they were trying to prevent. Having a citizen of a state left out in the cold to where the state could hurt them, could injure them, could take something from them, and they had no realistic redress. They had no way of bringing an action against the state and receiving any compensation, receiving any kind of redress which was again realistic for what had been done to them. This is the very evil that this document meant to preclude. But Harlan said, hey, wait a minute. I got some guys down here that kind of think maybe this is really not what they meant. There were only 74 of them. 39 of them signed the document. Now, there were 3 people, I think, and I may be wrong about that, but I think there were 3 that refused to sign the Constitution for whatever reason. But they were smart people. Well, Harlan obviously knew more than all of them. Well, in my opinion, Harlan was an idiot working on his personal agenda. I'm not going to go over the entire script of Hans v. Louisiana. You can find it online, and you can read it, and you can see that his references are totally misguided, that he was doing nothing more than trying to protect the states from being sued by their own citizens. Now, there are other cases related. There's a stack of documents related to this that, we're looking at stuff that's like 3 times what you can see between my hands here. I have just about all of that stuff. I've accumulated it over the years. And there's one case in particular that I find absolutely amusing. I don't know what to do other than laugh at it. A judge said that the fact that a state can't be sued preserves the dignity of the state. Are you freaking kidding me? You give the state the right to do whatever it wants to one of its citizens, to where that citizen has no realistic redress, and you say that's preserving the dignity of the state. You're turning the state into what, a criminal? It's like saying you and I can go out and do something to somebody and nobody can really do anything. But they use this, judges use this in every state in the union to keep someone from suing the major powers in the state, the governors, for example. In a case that I'm working on for John Sakine, which I've mentioned, I sued Phil Bryant. I sued him in both his official and his personal capacity. And when you bring a suit, that's generally the 2 ways that you come and approach someone through the courts. You sue them in either their official capacity or their personal capacity. And of course the court said, well, you can't sue them in their official capacity because they're protected. They have this sovereign immunity under the 11th Amendment. It's not what the 11th Amendment says, ever said, or ever will say. And it's definitely not what our founding fathers intended. This is where an outlandish interpretation has brought us to this point. And it's been going on since 1890 when Harlan decided to make it federal law. If the United States Supreme Court opines on an issue and they say this is a holding, then that becomes federal law. There are 3 things you get out of the court. You get a holding, you get judicial dicta, and you get obiter or obiter, I've heard it pronounced both ways, dicta. A holding means this is what we say officially in this matter, and if it comes from the United States Supreme Court, then it becomes federal law, and there are a number of cases, particularly one in the Fifth Circuit Court of Appeals, which upholds that precept. Judicial dicta is a very strong statement from a court, and it's a recommendation, and it's something like a guideline which maybe you want to follow, but you don't absolutely have to. And the other, obiter or obiter dicta, is something that a judge wants to say, sometimes a little more than women fancy. So you sue someone based on their official capacity or their personal capacity. And because of what judges say about the 11th Amendment, you cannot sue a governor, the head of a state department, in their official capacity, because it's just like suing the state. Now, are there any exceptions to this rule? And there are a few, and that is in state court. We have in Mississippi and in a few other states also this thing called a Tort Reform Act. And this, in some cases, allows a limited approach to suing the state. But even then, judges who are trying to gain favor with some politician, some crooked ass judge that doesn't really understand the law and what it says, will tell you, well, no, you just can't sue the state, and it doesn't matter what the Tort Reforms Act says. Tort Reforms Act is a little complicated. It involves time limits and a lot of other things, and it involves what is called a tort. Uh, you all know what a tort is when you go to the bakery. This is not the same kind of a tort. A tort, in legal terms, is when you have essentially been injured by an action of someone else. They have committed a tort. Um, there is a lot to be said about how tort law is taught in law school, and there's where many lawyers make their living because they go after people under the Tort Reforms Act for actions they have taken to harm another individual. Whenever you sue under the federal government, and quite often that comes under the auspices of 42 USC 193, you sue based on a constitutional deprivation. Something has taken, someone or something, some act by someone has taken away one of your constitutional rights. Whereas in a tort action, the damage, the injury does not have to reach a constitutional level. You cannot, for example, generally sue for malpractice under a 1983 action unless it reaches some level of deliberate indifference which results in a constitutional deprivation of that right. Whereas under a Tort Reform Act, you can sue for medical malpractice, you can sue for business malpractice, you can sue for an accident, and this is what so many lawyers do. So what I've done is go back and stick as close as possible just to the Constitution. As I said before, there's a stack of material related to this which is incredible. There are all kinds of laws and opinions and everything, but the most important thing is our founding fathers, the 74 delegates, I think there were 55 that actually attended, um, these were smart people. They gave us something for us, for you, for me, people that are just people, everyday people. They didn't put this out there for judges. They didn't put this out there for Harlan to say, hey, this is what they really meant. No, hell, it's not. It never was, and it never will be. They said exactly what they meant. They left that out of the Constitution. They left out the fact that you cannot sue your own state so that you would have that protection. Now, once again, here I am, an old country bumpkin. I just planted a part of a small garden. I haven't had that opportunity in the 18 years I was locked up. Planted some pink-eyed purple hulls, a few speckled butter beans, tomato plants, a few pepper plants, and I'm thrilled to have been able to do that. But, you know, I'm an old country bumpkin, an old hayseed, and here I am telling you that since 1890, we've been doing it wrong. You make up your own mind. You heard the words. Get a copy of the Constitution. Read the whole thing. And you'll be amazed at how brilliant these people were that put our Constitution together. They did exactly as they meant to do. They said exactly what they meant to say. Antonin Scalia reflected that when he said the script is the law. Scalia was a brilliant salon justice, an intelligent lawmaker. He had a way with words which was remarkable. I had just about as soon read Scalia in dissent as I would Steinbeck. It's amazing. But he said it so simply, the script is the law. And in our Constitution, which is lying right here beside me, the United States Constitution, it is clear, beyond any question, that our forefathers, the founders of this Constitution, the voice of the people, not of some blinking judge who has a personal agenda, the voice of the people says that you can sue the state as long as you are a citizen of that state. They didn't leave it out by accident. They knew what they were doing. Now, this concludes today's video. I realize it's not about Mississippi courts, but I did want to lay this foundation because we're going to be talking about the rights that Mississippi has taken away from us. Do you know how many times the Mississippi Supreme Court has granted relief in someone approaching them concerning the right to a speedy trial since 1992? I'll let you think about that one for a little while, and we'll talk about it next time. Again, I'm asking for your support. I'm not, as of yet, familiar with this VN program, which edits videos, so I don't know how to make this look pretty. I definitely don't know how to make me look pretty, but please give me your support. I'm asking for a subscribe and a like, and please, your comments. Those comments, as I've said before, will help to guide me in this fight. We are going to have to see some changes, and if there's anything I can do about it, you've got everything I've got. I will not let you down. Thank you all. God bless.